Is the Department of Justice and Correctional Services a ministry stumbling from one crisis to the other and failing to implement constitutional promises of South Africa's democracy? Or, as others believe, is it a ministry doing its best under very difficult circumstances in the battle against corruption and state capture? Good evening and welcome to Unfiltered. I'm Sizwe Mpofu Walsh. From victims of Apartheid-era atrocities, the Marikana massacre, and others still waiting for justice, to the administrative and other challenges that have caused international embarrassment, the department has received more than its fair share of negative headlines. And joining us to discuss these and other questions, I'm delighted to invite Minister Ronald Lamola, in charge of the Department of Justice and Constitutional Development. But first, let's watch the scene setter to get some context for our discussion.
The investigative directorate is as toothless as the NPA itself. To date, that directorate has not done any of the things that were expected out of it. Many high-profile criminals are walking around unbothered, and many of them, including their enablers, are walking around with blue lights as cabinet ministers in this country.
We continue to provide the necessary support to the National Prosecuting Authority, and as I've said, we have given them an additional grant of 915 million for them to be able to attend to the crippling challenges of crime that the country is facing, organized crime, corruption, and related matters, including the challenges that are faced by state-owned enterprises. And you will realize that there are cases that are already enrolled related to some of the state-owned enterprises, Eskom, Transnet, PRASA, and there's also been about 4 billion reparation amount that has been paid back by ABB to the fiscals of this country. So that shows that the wheels of justice are already rolling in this regard.
Defending his ministry and his government, Minister of Justice and Constitutional Development Ronald Lamola has been at pains to explain to the country that his department is making headway, having achieved unqualified audits in the past 2 financial years. Currently at the center of finding a solution to the International Criminal Court's arrest warrant against Russian President Vladimir Putin, who is expected to attend the BRICS summit in South Africa in August, the Department of Justice and Correctional Services has been mired in embarrassing developments of international scale. It has recently had to defend the brazen escape of rape and murder convict Thabo Bester. It's currently engaged in efforts to extradite the state capture accused Gupta family and fraud accused Shepherd Bushiri, who escaped South Africa under questionable circumstances. The escapes, coupled with the delays in prosecuting state capture-related crimes, as well as the embarrassing acquittal of the accused in the fraud and money laundering Nulani investment case, also state capture-related, have called into question the competency of the ministry and its prosecutions agency.
We are saying, at least on those straightforward cases, the NPA must perform. But in terms of the security cluster or the law enforcement agencies, whatever term you want to use, I don't think that we have competent personnel there. This is another department or sector which have been victims of the so-called deployment policy of the ruling party.
The department is also tasked with ensuring the proper administration and access to justice by all. It has to turn around and transform the justice system and, among others, ensure its modernization, reduce court case backlogs, and ensure that the courts are maintained and functional. While the NPA has been criticized for dragging its feet, the Special Investigating Unit, also under the same department, has been praised for its steadfast pursuit of criminals and ensuring recoveries from the proceeds of crime on behalf of the state. Almost 30 years into democracy, justice remains elusive for most South Africans who struggle to access their constitutionally guaranteed basic rights such as water, health care and housing. claiming these rights in the courts is difficult due to the prohibitive legal cost for poor South Africans and victims of gender-based violence. According to the 2022 World Bank report, South Africa is the most unequal country in the world, ranking first in a list of 164 countries in its global poverty database. And it has one of the highest rape and female murder statistics in the world. Andrew Mokhatle, Unfiltered, SABC News.
Minister Lamola, thank you for joining us on Unfiltered.
Thank you very much.
Where do you think the fight against corruption and state capture stands, particularly under your tenure as minister?
Yeah, thank you very much to the viewers at home. I think we have laid a foundation. You will remember when the current president took over, the NPA had struggles. They could not even hire what is called aspirant prosecutors. So we had to look into the budget and also ensuring that they have the necessary support to deal with the appointment of the necessary skills from aspirant prosecutors to the skilled prosecutors, including appointing what is called Section 38 senior counsels in terms of the NPA Act. And from the beginning, the president then did a proclamation to proclaim what is now called the ID, the Investigative Directorate, because it was clear that with the cases coming out of state capture, they needed a dedicated investigative directorate and the focus that must deal with it. That comes with a budget. They've now laid the foundation in terms of appointing staff. I think they've got more than 100 staff as we speak, an institution from 2019 up to now. And when you look into the budget of the NPA, it's one of the few state entities where the National Treasury has put additional budget. I mean, from that period upward to now, from 2019 up to now, it's almost an additional budget of about 3 billion rands to 4 billion rands to enable the NPA to revive itself, to do the work that it's supposed to do. So I do think that a good foundation has been laid. What we now need to do is to ensure that the structure becomes permanent so that there is certainty amongst the employees of the ID, because when it's not permanent, they are not sure, they want to leave at us and so forth. So once there's certainty, there's clarity, I do believe that the structure will be able to prosecute the matters that came from the Zondo Commission. And also there's been work that the president has done in terms of coming up with the Anti-Corruption Advisory Council, which is focused more on dealing also with preventative measures, because the cost of dealing with corruption while it has happened is very exorbitant, it's costly. We have seen it on our side. But to prevent it from happening is what now we need to deal with as a state. And that advisory council will help us to deal with that. But not only the state, civil society, the private sector, and everyone has a role to prevent it from happening.
I wonder what you make of the Chief Justice's recent comments. You just mentioned the Zondo Commission, where he said, albeit in relation to Parliament, that if another group of people wanted to capture the state, there would be nothing standing in their way, certainly from a parliamentary perspective, to do so. How do you respond to the author of the Zondo Commission making such a startling statement?
The commission, if you remember, was supposed to take, I think it's about 2 years or so. Or according to the former public protector, the recommendation was 6 months. How many years has the commission taken? About 4 years or so. And even in those years, the Chief Justice, who was the chairperson of the commission, requested lots of postponements, which at some stage ourselves were a bit reluctant, but we accepted because we understood the need to conclude the work of the commission. Hence, we supported that the commission's perpetual request of extensions should happen. But that is the reality of what happened. And the state in that period was also preparing itself as the report comes. I mean, that has proven that investigations and decisions to prosecute and also to make recommendations, for example, in some of the instances, there are laws that must be amended. National Treasury has already dealt with some of those laws. We have also dealt with some of the laws that must be amended. We are also in the process now, as we speak, to amend the NPA Amendment Act, the one I spoke about earlier, in terms of the ID. So amending laws is not an overnight thing. So we are indeed implementing the recommendations of the Commission. And there is discussions, even in Parliament, they've got their own discussions, how they are going to ensure that they hold us account, and also themselves implementing the commission, the recommendations of the Commission. If you remember, the President also submitted what we are going to do, how and when. And we are following through all those processes, including to give the additional resources to the relevant law enforcement agencies to ensure that they do their work. And we unfortunately, we don't prosecute, investigate, but we can only give them the resources to do the job, which we have done.
In terms of those legislative amendments, especially around the independent investigative unit within the NPA, do you have any sense of a timeline as to when that's going to happen? Because it already has taken quite a while, and the NPA at a recent parliamentary briefing said they have to wait for that until they can really get on with the business of prosecuting many of the complex cases.
Yeah, I think before the end of July, we will have published a bill in that regard. Obviously, as you amend the NPA Act and dealing with the permanency of the ID, remember, you have also to do internal consultations. There is the Hawks in terms of the Act, that they are already there dealing with some of the matters that the NPA is supposed to deal with. So all those roles needs to be clarified internally so that when government now speaks and say this is now the bill, there is there is clarity of thought in all the stakeholders within the state. And we are at the final and advanced stage of that consultation. So I do think that before end of July, we will have published a bill dealing with this aspect.
When I look at the former the current Chief Justice's statement, and I look at what's happened in Parliament, one of the things that characterized the state capture era was when the ANC used its parliamentary majority to shield its top leader from scrutiny and investigation. Didn't we see exactly that over the Phala situation? When the president was under pressure and under scrutiny, the ANC did exactly what it did during the state capture era, and you were actually part of leading the charge to defend the president on Phala. Is there any difference between what the ANC does now and what it did then?
Yes. If you remember, we followed all the processes. It is the committee, the Section 89 committee, established in terms of the rules of Parliament. And the rules of Parliament says Parliament must scrutinize, must consider, must debate the report, which we did. And we said this report is flawed. It has not considered a number of factors which we outlined, which is in line with the parliamentary rules. And I think we have done what the rule says, what the law is expected of us to do, and it is not stopping any investigations. Even that committee, the president cooperated with that committee's investigations. He gave them the information, but unfortunately, their report was not, it has a lot of flaws, which not only the ANC has pointed them out, even academics, even legal practitioners. There was consensus in society that indeed this report does not meet, it's really flawed completely. So you cannot expect, it's not that the ANC used its majority. It has just said the report is flawed. It cannot be relied upon to then institute the inquiry of impeachment. That was the point, and we are not shielding anyone, and that's why the Reserve Bank has to continue whatever they are doing with regards to the matter. The Hawks, they must continue. The NPA have not been stopped if there is anything that comes from the Hawks. So we are not stopping anyone. We are just saying due processes must be followed, and the president has said he's not above the law. He has subjected himself to the processes. I don't think it will be fair for me to compare with the Nkandla one, but at this stage, I can just say, and it suffices to say, we have handled this matter in line with the parliamentary rules, and that's why even the decision of the court when ATM went to court, the court said, no, we can't tell Parliament what to do. Parliament has followed this process.
Well, the interesting thing about that is that a lot of your speech in Parliament, but also a lot of what the ANC parliamentarians premised their speeches on, was that this report was going to be challenged and that those flaws that you allege exist in the report would be challenged. But then the challenge was withdrawn. And the findings of the report then haven't been challenged. They've been voted against, but not actually challenged. So those findings, it would seem if there were such flaws in those findings, one would be rushing to challenge them. But actually that challenge was withdrawn. So South Africa is now in a strange situation where the findings exist, the report was voted against, but nobody's actually challenging the findings.
For what? In terms of the rules of parliament, it says the report belongs to parliament. It's for parliament to process it, scrutinize the report, agree with the report, goes to the next process of the inquiry. If parliament says this report is flawed, we don't agree with it, it's the end of the matter.
It's the end of the matter politically, there's no doubt about that. But it's not the end of the matter in terms of the veracity of the findings. And again, that's the difference between the parliamentary majority and the actual truth of the matter. And the question is...
It's the end of the matter in terms of the veracity. What else?
It's the end of the matter in terms of the political act of voting against the report. But nobody's challenged the actual findings of prima facie wrongdoing.
No, we have challenged it in the platform which is established by Parliament.
You challenged
Parliament
it,
in
you
terms
challenged
of
it
its
saying
rules.
it was going to be challenged in court. Subsequently, that challenge was withdrawn.
No.
So
I mean,
so
whoever was challenging in court is the president. He
Yes.
was exercising his rights. What we did as the ANC was to show the flaws in the report. So we did not rely on the fact that someone was challenging it. We just said there are flaws in this report. This report cannot be relied upon to lay the basis for the inquiry because it's flawed.
why wouldn't we as South Africans want a further inquiry after a former Chief Justice, other independent counsel looked into the matter and said there's something to inquire into? Why wouldn't we give South Africans the benefit, not of impeaching the president, but at least looking deeper into that question instead of just stopping the report even before we could
There's no one who has denied. If there's any other process, the president subject himself, and we also subject ourselves. And that's why the public protectors process were not stopped. They continued, he subjected himself. And it's also an independent process. The Hawks process, the NPA process, no one is stopping it.
But the parliamentary process is a different process because that's where the president's impeachment...
So are you suggesting that we're supposed to accept a flawed report?
Question, sir. Let me finish.
Maybe let me ask you, are you suggesting that we're supposed to accept a flawed report?
Well, you earlier said that society was at consensus that the report was flawed. I'm not so sure that's true. Firstly, a former Chief Justice authored the report. It was unanimously authored. And there were many legal analysts who thought the report was actually correct. So I'm not sure where the consensus comes from.
But there was also a lot of them who said it was
So that's not
flawed.
consensus, that's
No,
disagreement.
but I think when you look at most of it, there was some kind of sufficient views
There were some
that
people
this
in the
report
media,
is flawed.
but other people also believed it was.
Yes, they did, but I think the majority of legal experts were very clear that this report is flawed.
I saw one or two legal experts. I don't know if there was a poll of legal experts, but I think a former Chief Justice is also
if you want
a
to
legal
indulge
expert.
in polemics and semantics, I don't think it's necessary for this platform. But the reality is that a number of legal practitioners did say this report is flawed, and we subjected ourselves to the process. We did not run away from the parliamentary process. We went, we considered the report, we looked at it, said the report is flawed. And that is a due process established by the rules of parliament, by the constitution, and it's also an outcome of what the Nkandla judgment said, that when the report comes, it is up to parliament to scrutinize it, decide on the basis of the substance of the report, what they want to do with it. And we said the report is flawed.
Let's go to our first break and we'll come back on some other questions of international importance. You're watching Unfiltered. At SABC Unfiltered is our hashtag on social media. Don't go anywhere. We continue our conversation with Minister Ronald Lamola after the break. Welcome back to Unfiltered. I'm still in conversation with Minister Ronald Lamola. Minister, let's come to matters of international importance. You recently made statements that you were considering domesticating the Rome Statute to avoid this problem with President Putin when he arrives, or if he arrives, for the BRICS summit. Can you give us an update on where that process is at the moment?
I think that was a misquotation by whoever said that, because I answered a question from the IFP about, with regards to the Rome Statute, is that we are considering or looking at amending how the Rome Statute was domesticated, because it is already domesticated. So I can't domesticate what is already domesticated. So we are looking at amending how it was domesticated so that it can provide for immunities for heads of states when we host conferences of international magnitude like the BRICS Summit, the AU, or any other conferences. So we are still looking into all that processes. We also have to engage with the ICC itself in terms of how we deposited the instruments for us to enable us to deal with the issues of domestication. So that is where we are and at that level.
And any idea as to when that process might come to finality? Because it's been difficult to assess exactly where government is standing on this. I know these are complex legal issues, but can you give our audience any indication as to that timeline?
I think also by or before end of July, we'll have clarity with the ICC processes in terms of how the instrument was deposited and how we then deal with the issues of amending the domestication process.
To what extent do you think that amendment to the domestication process could actually water down our commitments in terms of international law? Because the Rome Statute's very clear, states need to cooperate in achieving the statute's aims. We would essentially be diluting our commitments under the Rome Statute. Do you think we would be watering down our commitments?
No, we will not be watering down. It has always been customary international law. Hence, when you look at other countries that deposited or signed into the statute, they have done it with certain reservations. Like Britain, they did their own reservations, which deals with exactly the same aspect we're dealing with in terms of immunities for certain heads of states and when it may be difficult for them to implement the statutes. The Netherlands also have done it in a particular way. So it's international law across all treaties that countries sign. They always find ways. They reserve some of the statutes that are there. Not only the Rome statutes, various ones. You will have heard also Minister Mtswaledi saying we have signed some of the treaties stock and barrel. So it is clear now that 30 years into democracy, some of the treaties and the that's who have signed. We could, on hindsight, we could have signed them with reservations, which enables the state to still play its role in international law in certain circumstances.
Could I ask you, I mean, that's going to take quite a long time. I assume the amendment would have to go to public participation. Will we have enough time between now and August, if you say the process is going to finish in July, to actually amend our laws to facilitate President Putin's arrival?
Yeah, no, it's unlikely to have been concluded by that time. Because, as you are aware, our lawmaking process can take some time. But we will be able to finalize the position and put it out for the processes of the public, for parliament and all that. But that it could be done before August, it's highly unlikely.
Right, so this is more of a future-oriented, if we're ever in this situation again, we would then be prevented from this bind that we're in, either way.
Yes, it's because many countries, when they sign these type of treaties, they do it with reservations and so forth. So we signed and domesticated everything without reservations that enables international relations, which is polycentric and has got a lot of dynamics, diplomatic and so forth. So it needs to give you that flexibility and space. So that is what now the current South African government is looking into, not only on the Rome statutes and various ones, including the one that Minister Mtswaledi is also dealing with on the various international issues, how we have signed the treaties. So we are looking into that in terms of issues of looking at reserving some of how we have signed the treaties.
Yeah, it's quite interesting because I think, it's interesting that South Africa has just accepted every part of these treaties, and it's completely international practice to reserve and protect your own interests.
Yes, but we were a new democracy. Ourselves were having benefit of insight, so we need to use the lessons that we've learned.
Absolutely. Yeah. But that means we still are in this bind, though, if President Putin does arrive, and I guess your ministry is going to be in a very tough position because ultimately you are going to be, in some ways, the ministry at the center of that legal dispute to the extent that it does arise. The DA has gone to court to try and force a compliance with our law in conformity with the Rome Statute.
Yeah.
Can you give us any clarity on what you intend to do? Will you challenge, will you try to defend government's actions in court if President Putin does arrive? Can you give us some insight into where the department and the ministry will go?
Obviously, we can speak on what the domestication means, is that we have got obligations to cooperate with the ICC as and when we are requested. That is what the domestication of the Rome Statute means. But there are processes that are followed. And one of them is what you have just said in terms of the requests that come from the ICC. And such requests are confidential. Even the statute itself, and when they send you the request, they tell you that it is confidential, what you are expected to do. And it is for that reason that you will have, the South African government has approached them to request that, can we disclose some of the aspects in dealing with this issue? So that's why it's also a bit difficult for us to say, we are not going to arrest him or we are going to arrest him. Because there's confidentiality in how you implement the Rome Statutes as a requested state when you are requested to do so. So it is sent to all countries of the world. This request is not only sent to us. And there is a confidentiality undertaking that the ICC expect as you deal with this type of matters. But I think with time, we will be able to say this is the situation and this is how we're going to deal with the matter when we have followed all the processes of engagement with the ICC.
Another international issue is, of course, the Gupta extradition. The appeal, can you give us a sense of the status of the appeal of the decision not to extradite the Guptas?
Yeah, you will have seen a week or so ago, we issued a statement that we have met with the Minister of Justice in the UAE. And it became apparent that there is no longer a process of appeal. That process is exhausted. What we now need to redo is the resubmission. And there was agreement that both prosecutors from both countries must cooperate with each other, working, engaging on how we are going to then deal with that process. And therefore, the UAE authorities will then authenticate, confirm that the documents are in order, as they did previously. And we resubmit. So we are working on a resubmission.
So this would effectively be a fresh bid for the extradition.
Yes.
Now, in Parliament, you recently defended the extradition. Many people accused you or the wider Justice Ministry or Department of bungling this extradition. How do you respond to that accusation, particularly with the wider criminal justice system and the expired arrest warrants? Did we not dot our I's and cross our T's in this Gupta extradition?
Yeah, as I was saying earlier on that we deal with extraditions on a day-to-day basis. Mutual legal assistance. There's no one in this country who deals with them more than us. I can say it's our daily bread. It's something we do every day. I receive them. The DG receives them, the NPA. So there's a process. As the central authority, we have enough capacity and expertise on extradition. We do it for countries here in South Africa. Another government, for example, in Malawi, Bushiri, they are doing it for us in Malawi. And it is the prosecuting authority of Malawi that will then go and represent the government of South Africa in the courts of Malawi. As they go and represent us, they tell us, these are the documents we need, this is the information we need.
Right.
We submit the documents, and we did the same with the UAE. This is the information we need for you to comply with the extradition agreement. Both the central authority, the Director General of Justice in South Africa, the NPA representative, and the central authority of the UAE and the prosecuting authority in the UAE sat together. They agreed that these documents are in compliance with the extradition treaty first. The UAE guys agreed that these documents are in compliance with their processes in the UAE, with the laws of the UAE. They took the documents to represent us in the courts in the UAE. They say the documents are complete, they're enough. Even with the issues of the cancelled warrant of arrest, as I asked why was it still submitted, they said no, it was submitted for the sake of completeness, to show.
Let's leave it there, Minister, because we need to go to another break, but we'll come back after the break on these and other questions. Stick with us on Unfiltered at SABC Unfiltered. We're in conversation with Minister Ronald Lamola. Welcome back to Unfiltered. I'm in conversation exclusively with Minister Ronald Lamola. Minister Lamola, can we come on to questions of Apartheid-era crimes and their resolution? There was a proposal of an inquiry into unprosecuted TRC crimes, which was mentioned by Shamila Batoyi, head of the NPA. Do you think such an inquiry is necessary? Where are we with that inquiry? Has it been instituted? I haven't seen much on it.
Yeah, I thought you'll allow me to finish on the first question, but I hope viewers will get clarity in future. But the point I just wanted to make
Why
is
don't you round off for a minute on that?
We complied with everything. And the authorities there said everything is in order. They took for us and argued on our behalf in the UAE courts, and the courts of the UAE ruled in the manner that they ruled. It's like here in South Africa. I can't represent you and come back to you and say there was a document that was missing when I went to court on your behalf. So we complied with everything. With regards to the TRC, indeed it's a sad situation that 30 years into our democracy, we are still dealing with this matter. Indeed, they are looking into that investigation, which is headed by Advocate Ntsebeza, which will tell us what the future looks like and what they need to deal with in terms of the investigations and so forth. But at least as we speak, we did put additional resources, money that was put to deal with both the investigation and the prosecution, including a dedicated special prosecutor to deal with the prosecutions of these matters with regards to the NPA. That's how we take them very seriously, and we are hopeful that they will be able to take decisions, engage with the families, give them feedback, because they did raise that some of the challenges is that witnesses have passed on, some of them are passing on, and so forth. But we are hopeful that with the resources that we have helped them to get, they will be able to handle the matters.
Well, you say some of the challenges are with witnesses, but others, including Vusi Pikoli, who was the head of the NPA in the early to mid-2000s, have alleged that there was and there has been political interference in TRC prosecution cases. From your vantage point, do you think there's merit in that allegation?
Yeah, hence that investigation is expected to deal with that, and how then do we ensure that if it did happen, it never happens again, and if it did not, what are the measures that must be put in place so that the processes must unfold. But from our side, we have helped to provide the resources that they need so that they can handle this matter independently and with the sensitivity that it deserves.
We see the Cradock 4 have decided to sue the NPA either for the delay or not taking this case forward. Why has the ANC government been so slow to prosecute apartheid crimes?
Yeah, that is the thing that I was raising earlier on, that the investigation will have to deal with that, the one that is dealing with the matter, looking into it. But we, as I said, have put resources as we speak. There is a prosecutor special dedicated to this matter, including with the Hawks, to handle it. But as to why it took so long, I mean, really, it's 29 years. I also think that it could have been faster earlier. It could have been handled. We could be dealing with various things today. We have got more priority crimes and so forth. But it is here, it is with us now. We have to give them the resources. There must be closure for their families.
You recently led a summit on South Africa's constitution. And there have been interesting calls. I won't say consensus in society, but there have been a number of voices who have questioned whether the Constitution itself is sufficient to take us towards justice for apartheid victims, towards land justice, towards a more just economy. Why do you think the Constitution in its current form is still fit for purpose?
I think the Constitution is a transformative document. It does enable us to enact various laws to deal with the various issues you have said, the socio-economic issues, justice issues. It enables the processes of the TRC, it enables the NPA to proceed where there's evidence, issues of socio-economic rights. It was because of the Constitution that some of them were realized, the housing issues, issues of access to medicine and so forth. I do think that the Constitution, it is a transformative document. It can enable the transformation that we want. But it does not mean that with our lived experience, if there is a need to amend, we should still be able to say on this specific clause of the Constitution, we think we are not moving fast enough. If we can tweak it this way or that way, and there must be discussions and consensus on that aspect, and we deal with it. But I don't think it's the overall ethos and purpose of the Constitution. It's philosophical posture is very clear, it's transformative and so forth. Substantively, that is there. The lived experience is what we need to deal with. If there's a need to amend, let's do it. Where we are supposed to do and be specific, this is the aspect. But I find it sometimes difficult because in certain situations you could see that it is because we moved slow. I mean, for example, on the issues of land, we moved a bit slow in terms of dealing with the redistribution, the restitution processes. We have just recently enacted a permanent land court for the first time in a democratic dispensation. The president will soon sign the bill into law to create a permanent land court to deal and help develop jurisprudence in that space, which is something we could have done earlier, including issues of expropriation, to deal with just and equitable compensation or non-compensation, all those things. So in my view is that ourselves now that have got the experience of these past 30 years, need to use that lived experience to say this is how we must now move forward to fast track the issues of socio-economic transformation.
So do you then accept that government's own failures, a government in which you now sit, has undermined the constitutional project? It's not the text that prevents real and radical transformation. It's actually that government itself has not done what it could have done with the text that it has at its disposal.
Yes, there are things that we could have done. I mean, we could have expropriated it in certain circumstances and allowed the courts to clarify whether it was done in accordance with the Constitution or not. There should be certainty on those aspects. So indeed, there are where we fail, but there's where we have got successes. I mean, there's some parts in terms of redistribution where it's clear that we have done our part to redistribute some of the land. The restituted land, we have done. Unfortunately, some of them is now lying fallow, no longer being in use. Those are lived experiences that we have to attend to ensure that we provide the support and all that thing. So even with the issues you have raised in terms of the justice, for access to justice, the crime level and all that, obviously, there is a feeling that it looks like the Constitution has become too soft to criminals and so forth. So we need to deal with also those aspects. How to ensure that citizens can still feel free and safe in a constitutional project, which I do believe that with the implementation of laws, those who commit crime, found guilty, they are taken through the processes, there will be a clear rule of law. But that can only work when all of us work on the project.
One of those amendments that you alluded to earlier was the amendment to Section 25, which didn't materialize. On this show, I interviewed Julius Malema, and he said that you were the key impediment to land reform. How do you respond to that charge? And were you responsible for frustrating land reform efforts, as he charges?
No, not at all. We in the ANC, and I've said even at that time, that we believe in the mixed forms of ownership. That the state owns the land for its own use or to lease it. The individuals still must own land because it gives them value. They must get some form of a title deed, or private ownership should still be allowed, and also communal ownership, which is the current land setup in the country. So where we disagreed with the EFF is that the EFF said we need to take all land and put it under the hands of the states. But the question was, what is going to happen? We already have black people who own lands, who have got title to their lands. It's the whole of Soweto. You will have dispossessed them with a barrel of a signature. Someone in Soweto must now lease from the state. Someone in Soshanguve must now lead from the state. Someone in Ligazi, in Guamashu. They have worked hard. And you are taking them back to the eras of apartheid, where black people were perpetual miners. They can't own their own resource. So that's why as the ANC we said no. As we deal with the amendment to the Constitution, which we are agreeing, Section 25, it must say that we must be able to expropriate land in certain defined circumstances. Right. Not to take all land and put it under the hands of the state, because that will kill the value of the whole land for everyone.
We're in conversation with Minister Ronald Lamola. Make sure you continue to participate in this conversation on social media at SABC Unfiltered. We look forward to wrapping up and rounding off our conversation after the break. Don't go anywhere. Welcome back to Unfiltered. We're in an exclusive conversation with Minister Ronald Lamola. Minister, in terms of the question of the funding of the NPA, there's been a lot of song and dance about whether the NPA will accept private funding. You've said that the extent of private funding so far is in kind. Do you not think that even that amount of private funding, as munificent as it might be to help victims of gender-based violence or other support functions, do you not think that there's a danger of, once you open the gates to private assistance of such an important state institution, we end up losing the power of the state to be independent in its prosecutorial work?
No, there's no danger. Because if you look into the budget, the whole budget of the NPA, as a sovereign country, is funded by the state. The whole operations, all that. And as I've said earlier on, that we, in the past 3 or 5 years, we have increased additional to the NPA, put a budget of more than 3 billion rands, so that they can be able to appoint, to get the necessary skills and so forth. But you can't take away the reality that it may not be enough to cover everything. The point you are raising on gender-based violence, as an example, in the Tutuzela care centers, where the NPA with the health department runs, there are victims of gender-based violence who need pads, who need various things there that must take care of the victim. It does not affect the evidence, the court process, and all that. And the private sector came in and said, we can help in kind, even in certain instances with the buildings and so forth, which have played a significant role for us to get the victims to feel being part of the system and to help the system. That is an example. And I won't mention the name of the brand, for example. They have put it now in their paperback. When you buy, you get a toll-free number, how you can be helped in the Tutuzela care centers. They also, some of them help with the issues sometimes to say, we are a law firm. We have got expertise in this area. We are willing to second one of our own. That person can do it pro bono. It does not affect the work, but this is an expertise that the NPA need. So all those things, so that's why they are governed by the RDP fund of the National Treasury, how donations in kinds must be done. And also it is done in a manner that does not compromise the independency of the NPA. The prosecutor still makes the decision. They are not influenced by whatever in-kind assistance comes. And it is very, very micro, it's not nearer to whether this person must be prosecuted or not, which is a decision which cannot be influenced by anyone, even myself. The prosecutor must take that decision on his or her decision.
So I think you've clarified, and you've taken steps even before this interview to clarify the kinds of in-kind donations that have been made. But do you think, would you support in principle expanding, I know there are guidelines that are currently under discussion, expanding private funding to the NPA that could be cash-based if it was ring-fenced in a treasury fund, as has been proposed in some quarters?
Yes, it is done through, as I've said, the RDP fund, which is responsible for that. And then even the institutions they work with, there's no one who you can say has now bought this person from the NPA, because if this person is involved, he can, or he has got interest that they must prosecute his or her competitor or something. No, it cannot. The guidelines, they are very clear. They must be transparent, the process, and that's why even when you see it in the annual report, you can go and scrutinize who has done what were the purposes and so forth. It's transparent, it's open, so that there's no capture of the NPA. It is not going to happen. We will not allow it, because the Act, the NPA Act, does not allow it, but also the independence of the NPA is safeguarded by the Constitution.
So in principle, you would accept big donations, in-cash donations. What kind of guardrails would you put around that to prevent someone from being able to walk in and actually compromise the NPA from within, or at least create a perception that if in some ulterior universe suddenly they get charged, or there are major criminal allegations and there's no charge, people don't turn around and say, well, the NPA isn't doing it because they got this in-kind or cash contribution.
Yeah, that's why it has to follow the guidelines that are set up by the National Treasury. It states how and all those things, the processes that must be followed, which is true, and as I said earlier, is transparent. And by the way, is in all government departments. But I understand the concerns when it comes to the NPA, because it's supposed to be an independent institution. And that is why its budget, in 99% of the budget of the NPA, or I can say 100, comes from the state. But there are certain things that the state may not be able to finally have, all of them. The examples I gave you, where you may need a particular expertise that is extremely expensive. Or for example, of a forensic prosecutor or a prosecutor in the cyberspace and so forth. That person you can find that is only at Vodacom. And it's only Vodacom that can afford this prosecutor or this person who has got an expertise in cyber law or cyber expertise. And then if the NPA speaks to Vodacom or the National Treasury, they find a mechanism. How can this expertise of this guy from MTN or from Cell C with cyber technology or telecom or whoever expertise you can find in the private sector can come and help with this type of prosecution or investigation, because they are the expertise. And then they agree that no, it's fine, this is how we're going to do it. We will, this company will continue to pay, but they're not interested. The NPA, this is how you're going to pay him, or the Hawks, but it's going to be a capped fee. Those kind of things. We do need some of those expertise from time to time. And there must be a mechanism which they have put in place, guided by those guidelines.
Before we conclude, Minister, and we don't have much time left, just on the Thabo Bester debacle, you cancelled G4S's contract recently. Has there been any backlash on that from G4S, or are you confident that your decision was the right one?
Yeah, we are confident that the decision was the right one. You will remember that we took some time to make the decision.
And you were under a lot of pressure at that time.
Yeah, we were under a lot of pressure. But we took our time because we're consulting with lawyers. We scrutinized the whole contract. We've went through all the processes, all the reports that we have. And the advice was very clear that indeed there is a breach which warranted the action of a cancellation. Hence, they then sent the notice, which we are confident that it was done in line with the contract. And the PFMA, the decision can withstand any legal scrutiny.
And can you reassure South Africans that the ministry, the department, are leaving no stone unturned in terms of accountability for that breach in the correctional facility? Have you acted with all urgency required?
Yes, and hence you will have seen internal staff that are going through processes. Those that are external, those who committed criminal processes are undergoing the court processes, criminal charges and so forth. And we will allow the law to take its course.
Minister Lamola, thank you so much for joining us on Unfiltered and fielding the tough questions.
Thank you.
Thank you very much for joining us on Unfiltered. We learned a lot today about Minister Lamola's tenure in government. We discussed questions of state capture and corruption. Has the ministry addressed and tackled state capture and corruption with the urgency required? Pala. There are also a wide range of international questions we covered, as well as some of the internal administration of justice over which he presides. Let's continue this conversation on social media. Thank you so much for joining us at SABC Unfiltered, and we'll be sure to catch you on the next installment of Unfiltered News, Unfiltered Views, and Unfiltered Conversations. Good evening.